this time, we have joining in the discussion Ronaldo Rollocks, consultant at Millennium Human Resource Consultants and Associates. Mr. Rollocks, we welcome you to the conversation.
Yes, good night, Alana, and good night to the viewers on Facebook and those via YouTube as we attempt to discuss this most troubling issue of vaccination and mandatory vaccination as it is purported to be. Fact is, no one has mandated thus far that that be so, but we are seeing in different workspaces there are different types of correspondence that are troubling in some manner. In navigating the advent of the COVID-19 pandemic and its effect on employees and employers, however, there are some key issues that must be part of any fruitful discussion. And the fact is, we cannot successfully contrive a solution to this very complex industrial relations and public health phenomena if we continue to base our analysis on feelings and propaganda, on rumors and isolated circumstances that may be true, but for various unsubstantiated reasons, on mischief and misinformation. Thus, I'm saying labor on both sides, carry an indispensable responsibility to educate themselves and their workers to help those who are hesitant for a plethora of reasons that may be based sometimes in ignorance. The state has been doing its part, and so must we. As a people, we have been fed too many polarized arguments and options which are divisive in nature and only deepen a very controversial issue. There are certain key facts, however, that we must keep in mind when discussing the idea of vaccination and mandatory vaccination and policies. Firstly, where there's an RMU, a recognized majority union, and a registered collective agreement, alterations to the terms and conditions of employment can only be done via consultation and agreement with the recognized majority union representing those workers. That has been established. That is not news. That is a principle in industrial relations as it stands. All other workers that may not be unionized will be governed by a contract of some sort, and as Mr. Matteson explained, whether oral or written. And here as well, unilateral variations of this contract, these contracts of employment, may not find favor. So we are saying outright that a very ad hoc approach to this vaccine issue could land an employer, depending on how the issue is approached, in some trouble. One must admit, however, that there are certain factors which employees and employers must take into consideration in examining the mandatory vaccine issue. There are several important considerations. One, the fact is a court will consider the science of the phenomena in examining the rationale for the policy, not hearsay, not one's opinion, not gossip. What does the science say concerning the coronavirus, the vaccine, the efficacy of the vaccine, the evidential effects of the vaccine as it relates to public health? And we must understand and appreciate that this is a public health issue. Is the policy punitive? If there is the employer's policy punitive or preventative? This is a crucial question because, as we do know in law, as it has been recently decided at the ECHR on the 8th of April 2021 in the Czech case, the famous Czech case that went before the European Court on Human Rights, that no right is absolute, and even your constitutional rights can be at times abrogated in certain circumstances, one of which happens to be in public health, national interests, and national security. So whether termination is done by force or through mutual agreement, there will be, and we are saying to everyone, financial considerations. There will be consequences for both parties. Matters at the court, There'll be issues of severance payments, there may be injunctions, there may be JRs, and other legal maneuvers, which would be at least time consuming. Any decision of the employee or employer is therefore subject to challenge. Hence, one may try to avoid such a route. This is a pandemic, and we understand that financial resources are scarce, and these are tough economic times. So we don't encourage people to try to access the court and as their first option, understanding the times in which we live. Depending on the sector and the nature of the job, there may be other options available in discussion with the worker. There may be remote work options, as has been happening. This has been happening since the pandemic started. Why can't it continue? I would want to know. There may be redeployment options. There may be shift systems options. One will also have to consider the availability of the vaccines. In making something mandatory, one must consider if it's readily available. How accessible is it? Is the process onerous in any sort? Are you then placing a barrier to the continuation of the employment relationship? Are you locking out the worker? Have you constructively dismissed the worker? What do we do, therefore, with the exemptions? Those who, for very valid reasons, cannot take the vaccine because of medical issues, or in the short term are unable to be vaccinated because one, they may just have had the COVID virus and they are now, getting better, or they need to get medical clearance of some sort. Those groups of workers will still need to be considered. What do we do? Do we terminate them? How do we treat with them? So that issue of living and treating with workers and workers working without the vaccine in any form is still a real one, in my humble point of view. From any angle, we cannot and should not neglect the issue of dialogue and the need for dialogue. I am uncertain as to the effectiveness of a mandatory stance in achieving any reasonable success. Employers and employees must come together and examine the peculiar nature of the job, health and safety considerations, alternatives, new procedures, and mutual trust without taking a power approach to the employment relationship. And as I seek to close, I remember learned Judge Rabatali taught me recently in an IR course at Lockchat the Latin maxim, Odi alteram partem, hear the other side. From my humble experience, the court, moreover the industrial court, is a process court. Even though you may have good intentions, good reasons, good motives to do what you did, how did you do it? What was the process used? Did you terminate all those who were unvaccinated, including management? Was this your first recourse or last recourse? Did you consider alternatives? Did you have any discussion with the workers, or were they terminated by decree? Was the worker paid any severance, and how was this calculated? Was it fair? These are some very important questions that will remain in any conversation in dealing with mandatory vaccines and the consequences, because we do envisage situations where workers and the employer may come to a mutual agreement to part ways. That process must be managed carefully to avoid litigation of any sort or claims of injustice or unfairness on the workers' behalf. We do, however, understand that this is a pandemic, this is a public health issue, and therefore certain sectors of workers, for instance, we know in France and more so in the UK, health workers, their issue is a bit tenuous, it's different. Some sectors are very open to change and it's easy to implement other strategies, and some sectors it is not. So indeed, the test is upon us. Mr. Madison did state that there's no jurisprudence on the matter. So it's funny that many people are pronouncing on how the court will do and what the court will do. And we prefer to encourage employees and employers to educate themselves, the trade union movement, especially to help educate their members on the truth and the science about the pandemic and the vaccines and the options available. At the end of the day, this cannot be resolved without dialogue. Thank you, Elena.